Hello, I'm Steve Wood. I'm Head of Policy Delivery at the Information Commissioner's Office. My department is responsible for all the ICO's guidance and code of practice on the Data Protection Act. The GDPR can appear daunting when first looking at the text. There are many aspects of the text that practitioners can recognise from the current Data Protection Act they're working with. For example, many of the principles in the GDPR are very similar to the principles in the current Data Protection Act. But the General Data Protection Regulation does introduce an important step change in terms of data protection. The legislation is designed to deal with the challenges of the online world of the 21st century and the data flows that occur in that world. The GDPR does introduce greater rights for data subjects. It enhances the rights they've already got and introduces new rights. It also places greater obligations on data controllers, but they will now have to take further steps to demonstrate their accountability under the regulation. Today I'd like to outline 12 key steps that organisations can take to prepare for the GDPR. What I'm talking about today is very much a starting point. More guidance will become available from the ICO and the group of European data protection authorities, commonly known as the Article 29 Working Party, over the coming months and years. It's essential that you start planning now. You need to consider the areas that may require a long leading time, such as changing contracts, IT systems, personnel changes, and changes to your organisation's governance. You should assess the areas of the GDPR that are likely to have the greatest impact on your organisation. The first step I want to talk about is awareness. In planning for the GDPR, it will be very important that you consider where you need to raise awareness in your organisation. Who are the key people who will need to be influenced and be aware of the importance of the General Data Protection Regulation and the importance of protecting personal data? You'll need to start thinking about key decision makers, particularly perhaps people at board level or senior decision making levels in your organisation. You'll perhaps need to review documents that you already have in terms of perhaps risk registers and other areas relating to information governance. The second step you need to think about is considering the personal information you hold in your organisation. The GDPR places much greater emphasis on organisations being able to demonstrate and understand the personal data they are holding and using. For example, the GDPR places a much greater emphasis on organisations being able to produce documentation to the Data Protection Authority in terms of demonstrating how they're complying with the requirements of the regulation. The GDPR also focuses more on data flows and understands the nature of data sharing. So when one organisation shares personal data with another, it'll be important that you're able to demonstrate what personal data is shared and what steps you may need to take in respect of that data. For example, if you share inaccurate data with another organisation, if you then need to communicate the inaccuracy of that data to the receiving organisation to make that correction, you'll need to make sure that you have the right documentation of the personal data and the right procedures in place. The third step I want to outline is about communicating privacy information. So many data protection practitioners are familiar with the concept of producing a privacy notice, communicating to individuals, to the public, about how their personal data is going to be used and some basic information about the identity of the organisation. The GDPR sets out a wider range of information that needs to be communicated to individuals, and this will still probably be in the form of a privacy notice. There will be extra information to communicate, such as retention periods for data, the legal basis for processing the data, and also where an individual can complain to, including the identity of the national data protection regulator. The GDPR also picks up on the problems and challenges that have related to privacy notices over many years in terms of the lack of plain language, and the inaccessibility, and the GDPR places much greater emphasis on the plain and clear language that must be used, and the steps that data controllers should start to think about in terms of making sure the privacy notice is very easily accessible to an individual to get that key privacy information that the GDPR requires. The fourth area I want to talk about are the rights that individuals enjoy under the GDPR. These individual rights are really a cornerstone of data protection law. The rights in the GDPR build on the rights that have already been there in the existing data protection legislation we already know and work with. But those rights have been significantly enhanced, really to deal with the challenges of the online world and to ensure that people can have effective means to control the way their personal data is used. So the rights in the legislation that we're already aware of, subject access rights are in the legislation, the right to have inaccuracies corrected, the right to have information erased, the right to prevent direct marketing, the right to prevent automated decision making and profiling. Those are rights which we are familiar with under the current legislation, but they've become more prominent over the last few years through court decisions, particularly court decisions of the Court of Justice of the European Union. But they're significantly enhanced and made stronger under the existing legislation and made more prominent and explicit. There are also additional rights, such as the right to data portability, which is the right in certain circumstances for individuals to receive their personal data in a commonly used format so that they can go and reuse and make sure their data is portable so they can easily move their data to another service. It will be important that organisations start to think about the processes they will need to have in place to make sure that they can easily process requests from individuals to exercise these rights. So, for example, how will an organisation handle a request from an individual to delete their data? What different parts of the organisation will need to be involved in this process? How will it relate to the step I mentioned earlier about the documentation of personal data to ensure you can understand what personal data you have in order to carry out that request within the required time frame? The next step I want to talk about builds on the last area I talked about in terms of individuals' rights. So I want to talk specifically about subject access rights. That is the right that an individual has to request their own personal data from the data controller, a very important right. The data protection rights under subject access in the GDPR have some important new characteristics. Firstly, it's going to become more exceptional to charge for subject access requests. In most cases, it won't be possible to charge for subject access compared to under the current Data Protection Act, where it is possible for organisations to make a £10 charge. So organisations will need to review their processes and ensure they have the procedures in place to handle subject access requests under those circumstances. The other important thing to note is that the timescales for subject access are going to change. So previously, organisations had 40 days to comply with subject access. The GDPR talks about terms of 1 month. So organisations will need to think about adjusting their procedures to meet these compliance timescales. The other thing which is changing with subject access is the basis on which organisations will be able to refuse to handle the subject access have changed. So under the GDPR, organisations will be able to refuse to handle a subject access request where the request is manifestly unfounded. More guidance will be provided on that in the future, but organisations will need to think about how they will have procedures in place for considering requests to make sure that there are fair and transparent and reasonable criteria for considering requests if they start to conform those types of characteristics. The next step I want to talk about is the legal basis for processing personal data. This is important under the GDPR because the GDPR is very clear in making sure that organisations do understand the legal basis for processing personal data. This has always been an important part of data protection law, but it's made more explicit under the GDPR. Why is this important? because parts of the GDPR, for example, are calibrated to take account of the legal basis for processing personal data. So, for example, if personal data is processed on the basis of an individual's consent, that gives the individual the right to be able to request that data to be deleted under the right to erasure. So it will be important that organisations document and understand the legal basis for processing that data. And as I mentioned earlier, the legal basis on which they're processing the data will also need to be communicated to the member of the public. Organisations should start to think about the different scenarios and the different areas of their work where they are processing personal data and making sure they're auditing and mapping and understanding the legal basis. The next area I'd like to talk about in terms of a step that organisations must be aware of is the focus on consent. So consent has been a much debated area in the GDPR in terms of what the definition of consent now means. Organisations will need to think and review how they are seeking, obtaining and recording consent. The GDPR text talks about two different standards of consent. It talks about unambiguous consent for processing personal data in most circumstances, but then also talks about the standard of explicit consent for when processing personal data in the special categories, such as health data. There's been much discussion about the difference between unambiguous consent and explicit consent in the text and what difference there is between the two. From the text, particularly reading the recitals, it appears clear that both standards of consent should be regarded as high standards. Unambiguous consent is still a high standard to meet, and the recitals in the General Data Protection Regulation make clear that it must be a positive indication of the individual's wishes, and it must also be an indication that the organisation is actually recording and they can actually demonstrate that they have that consent. Silence, inactivity or pre-tick boxes, the GDPR explains, will not constitute consent. So organisations will need to think about the processes of where they're relying on consent as the legal basis for processing and making sure they can meet this new standard, or are they going to need to find a new legal basis for processing under the GDPR. Organisations will also need to think about the different ways that consent can actually operate and making sure they can meet both of those standards. The next important step I want to talk about relates to organisations who will be processing children's personal data. This is a new area for UK data protection law. The GDPR contains a provision that would require organisations to get parental consent when they're processing personal data of all children under the age of 16. The GDPR also contains a provision which would allow member states to reduce that age down to 13. We still await the decision of the UK government as to whether they wish to use their discretion to introduce the lower age. But organisations who do process children's personal data should start thinking now and should start to audit the different scenarios where they do collect children's personal data and start to think about the different ways in which they may need to obtain and verify consent, and making sure that it's proportionate to the risk and the issues and the circumstances of that particular processing scenario. It's also important to remember that the consent must be verifiable, so organisations should make sure that they have records collected from that process of obtaining consent so they can demonstrate that the consent has been collected. The next step I want to talk about is preparing for data breaches. The GDPR introduces the requirement for data controllers, organisations, to notify the Data Protection Authority, in the UK that would be the ICO, of a data breach when that data breach is likely to cause damage or distress or have an impact on an individual. Organisations will also need to consider notifying the individuals about the data breach as well as notifying to the ICO. This will be an important change for some organisations who won't have previously reported data breaches to the ICO. For large organisations with multiple systems and data held across many sites, you'll need to start thinking about ways in which you can document the data breaches, how those data breaches are managed across the organisation through to the process of both notifying the ICO and notifying the individuals if required by the GDPR. Organisations will need to think about their assessment systems, which key personnel need to be involved in processing and assessing the data breaches which are reported internally to make sure that the right procedures and policies are in place. Organisations may need to introduce new IT systems to manage and record these data breaches if particularly they're in large numbers. The next step I want to talk about is the concept of data protection by design and data protection impact assessments. The concepts of privacy by design and privacy impact assessments are long areas the ICO has highlighted as good practice for putting privacy first when designing new systems and making sure privacy issues are considered at the start. So it's very welcome that these concepts are now included on the face of the GDPR. Organisations will need to make sure they have processes in place of considering how they can actually implement data protection by design and data protection impact assessments in practice. Organisations can already consider how to look at data protection impact assessments by using the ICO's current code of practice on privacy impact assessments, which is available on the ICO's website. Organisations who conduct data protection impact assessments and they are assessing risks to individuals from processing personal data will also need to consider whether they need to actually seek the authorization of a data protection authority like the ICO when they are conducting a data protection impact assessment, because in some circumstances they'll need to actually have that authorization where they consider the data protection impact assessment does not mitigate all of the risks they have identified.
Okay.
The next step I want to talk about is the appointment of data protection officers. The GDPR sets out criteria as to when data protection officers must be appointed by an organisation. This could be a public authority or it could be an organisation who are undertaking systematic monitoring of data subjects of individuals. It will also be important that organisations think about the status of the data protection officer in the organisation. The GDPR is very clear that the data protection officer must report in to a high level in the organisation, which may be at board level, to make sure they have the opportunity to explain to the organisation's key decision makers about data protection risks. Organisations will also need to think about where the data protection officer sits in the organisation's governance and structures to make sure they have the right influence and the right ability to be able to influence changes in policies and procedures and how the organisation approaches personal data. And lastly, I'd like to talk about the international dimension in the GDPR. As we know, many organisations may have establishments in many member states across the EU, and therefore their data processing may span many borders. As a first step in terms of the international dimension of the GDPR, it is important for your organisation to consider where your main establishment is if you have many sites across the EU. You'll need to start to think about where your key decisions are made and thinking about the key aspects of your data processing in terms of determining where your main establishment will be. You should then approach the data protection authority in that particular EU country, who would be the lead authority in terms of overseeing your data processing.